Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial. Mm-hmm. So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance in counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, mm-hmm. and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case, of what I was trying to get straight with prosecution, and none of those questions were answered as far as the legal terminology that we're using.
So what they're charging you with? Or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly is being meant by the legal terms being used.
I'm trying to figure that out.
For example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so all right, transcript of past hearings. Something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
I wanted the communication between previous counsel and the prosecution, the case transcripts, and the bonds on record and oaths of office.
Okay, of the oaths of office of the prosecutor. Who?
You and the prosecutor, and for the attorneys that I previously had.
Well, for me, you could just go to the auditor, state auditor, or in the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office.
The Office of Assigned Counsel can't provide me with that.
You can certainly, ask them too. Ask them for their people what they have. I can't say.
Okay, I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to.
Because even though I'm representing myself, the court.
Exchange highlights a common issue where a self-represented defendant focuses on procedural or administrative concerns, such as obtaining transcripts, bar numbers, or prior communications, rather than the core legal question of defending against the charges. The judge repeatedly attempts to redirect the discussion toward trial readiness and the relevance of the requested materials. This illustrates the gap between legal strategy and perceived fairness, where the defendant believes broader systemic issues directly impact the case, while the court limits the scope to admissible and relevant matters.
We're still obligated to provide legal assistance.
the court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial. That would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
When I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
yeah,
I just
well,
don't want anyone speaking for me.
so you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. A lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be represented or deceived into taking someone else's opinion of how to handle things.
You don't get to kind of pick and choose how it's done. We've appointed counsel at one point, then you didn't want to do that. I could potentially, and I can't speak for the Office of Assigned Counsel. You know, they're the executive branch government. I don't run their office. I simply find if someone is indigent or qualifies for public defense and say, yes, they can have one, and then that agency takes over. But at this stage, so
When I was made pro se, that is what Judge Brent Buckley had discussed. He said that I wouldn't have counsel represent me,
yeah,
but that I had legal assistance. I
so
communicated with the Office of Assigned Counsel. They assigned me someone,
they did.
to help
Okay.
me. So
I didn't know
as
that.
far as I knew, that's what was going on.
All right. Have you talked then? I'm kind of wondering why someone's on here. All right. So since that you need to, have you had contact with that person since
Yes,
that
it's someone with the
appointment?
last name Thomas. I don't have it written down, but yeah, I've called and sent him some emails. I got him from the supervisor.
Mr. O'Connor?
Yeah, Mr. O'Connor,
Okay.
yes. He told me
All right.
someone, I think Alex Thomas or something like that, was
Okay.
someone he referred me to, and I've contacted them, but I haven't got a response back from them.
And when was that?
This was just before I got out of jail, so
Just the end of last month?
yeah.
Somewhere around there.
Yeah.
Okay. Or beginning. All right. Well, so, all right. So we're like 10 days to trial. You haven't talked to the attorney that's public defense has provided for legal assistance. And so is that part of why you're
Yes,
not
ma'am.
ready to go? Okay.
Yeah.
Because that makes more sense to me. All right. Well, let me turn to Mr. Abid, who's representing the state on that issue.
State would have no objection to a short set over, Your Honor.
All right. So now, just so you understand, you're asking for a continuance. It's a fair request. I would find what we call good cause for that request. But that would put us into an excluded period under the time for trial rules. And we would set another confirmation date, and we would set it, actually, we'd set a motion date, confirmation date. Let me look at these motions. Motion date, confirmation date, and a jury date. We'd send those to you in the mail. And if you'd like a text message reminder, we'd send you one of those too. And then going to go on the process. And then at that point, then you contact, I would think you would want to contact Mr. O'Connor's office and be sure that you can hook up with the person you need to and discuss all of this with them and then be back. But we're going to set that motion hearing so that we have everything done. Now, you filed everything. You filed a lot of motions. You've got everything filed. State needs to respond, and then the court will hear from both sides and make a decision.
This interaction also exposes the complexity of exercising the right to self-representation while still seeking legal help. The defendant wants control over their defense, but also expects ongoing legal guidance, which the court clarifies is limited to standby counsel. This creates a tension. The legal system allows autonomy, but not a hybrid model where the court actively assists. The situation demonstrates how self-representation can unintentionally place defendants at a disadvantage when they misunderstand the boundaries of the court's role and the function of appointed counsel.